Hi, government students. This lecture is going to be about civil liberties and incorporation, specifically the First Amendment. It's important, has many different parts to it, so I thought the First Amendment would be a good video to do on its own. Before I get into the First Amendment, just a bit of background again, right? So incorporation is the official term we use to describe the Bill of Rights being applied to the states. And this happens because the 14th Amendment, passed in the 1870s, includes what's known as the Due Process Clause. So states cannot deny citizens their rights or liberties without due process of law. So there's got to be some process for which states go through, a court case or some law that has to go through legal proper channels in order to deny you your rights. Okay? The first incorporation case is actually a First Amendment case. So 1925, Gitlow versus New York. The state of New York passed a law limiting free speech. Gitlow sued. The Supreme Court said, look, the First Amendment applies to all states. States have to respect freedom of speech, including you, state of New York. Right? So that gets us, and up through the 60s and 70s, and even today, we still have incorporation cases where the Supreme Court takes an issue, takes a law, and says, hey, this is a violation of a constitutional amendment. This amendment applies to the states. Okay? So let's look at the First Amendment, different parts of the First Amendment, right? So we've got freedom of speech, freedom of press, freedom of assembly, and freedom of religion. Freedom of speech has two parts that are similar but just slightly different, right? So freedom of speech is broken down into two things. There's political speech and symbolic speech. Those are protected forms of speech. Then there are non-protected forms of speech, right? So things that are not protected are anyone trying to incite violence or incite a riot, obscenity, so pornography, or things that are deemed obscene, and a clear and present danger test. This is shouting fire in a crowded theater. So those things are not protected, right? So as long as you're not doing those things, you're pretty much okay. The most common forms of speech that are protected, right, the Supreme Court deals with are political and symbolic. So political speech might be something like campaign finance issues. So the Citizens United case, it dealt with political speech. Can corporations advocate for a particular political agenda? And can we limit their ability to advocate, right? Can we limit the amount of money they can spend? Supreme Court said, no, political speech is protected speech. You can't limit them, right? Another case is Tinker versus Des Moines, or Des Moines County School District. Tinker wore an outfit that protested the Vietnam War and the draft. He was suspended from school. He sued, said you can't do that. I have a First Amendment right. My First Amendment right to free speech is protected even at school. The Supreme Court said, yeah, look, this is political speech. You can't punish the kid for expressing their political views. And there's symbolic speech. These are, symbols. Speech isn't just words. Speech can be art. It can be a variety of different things. These things that aren't words tend to fall into symbolic speech. So the case that's really noted is Texas v. Johnson. So the state of Texas had a flag burning law. You're not allowed to burn the American flag. Johnson burned the flag, was arrested, sued, said you can't do that. This is a violation of my First Amendment right to free speech. Supreme Court completely agreed with him, said you can't ban symbolic speech. Even if you think it's offensive, you can't ban it, right? As long as the person is not inciting violence, right? If the person is not inciting people to riot, if it's not an obscenity, right? If it's not just curse-laden, a curse-laden tirade or pornography or something, and it doesn't create a clear and present danger that people are going to be killed or something like that, it's all good. So that's why you can't ban burning the flag. Freedom of press. We have very generous libel and slander laws to try and protect our free press. We don't have censorship laws that prohibit what the press can publish ahead of time, right? You can sue a newspaper and be like, that's libel, that's slander, but you can't stop them from publishing something ahead of time. Freedom of assembly, right? As long as your group is not inciting violence or conducting obscenities, you're good to go, right? You can assemble with whoever you want. Then freedom of religion. And freedom of religion is broken down into two different parts. There's the free exercise of religion, right? So government can't prohibit you from practicing your religion or practicing no religion, okay? And then there's the Establishment Clause, which states that the federal government cannot prevent you, or the federal government cannot endorse, advocate, support any religion. We can't have state-sponsored religion. We can't have state-endorsed religion. Okay? So for the free exercise clause, good case to know is Wisconsin versus Yoder. So this dealt with the right of Amish parents to keep their kids out of public schools, so they could keep them within their Amish communities, educate them within their Amish communities. Supreme Court granted them that right because it's an integral part of their religion, allowed them to do so. Just like Jehovah's Witnesses, there's a case that deals with Jehovah's Witnesses going door to door, proselytizing, right? They're allowed to do that. Their communities have banned Jehovah's Witnesses and Mormons from going door to door. Supreme Court said you can't do that. It's a violation of their freedom of religion to go out and advocate for their religion and try and convert people. Then there's the Establishment Clause, right? Government cannot establish religion. Government cannot endorse religion. And so the question is, what does that mean? Whether or not the government is endorsing religion comes from this case that's known as Lemon v. Kurtzman. Most people just know it as Lemon because it creates what's known as the Lemon Test. The Lemon Test is the test to see whether or not the state, the government has violated the Establishment Clause. And so in the Lemon case, a city in Pennsylvania passed a law that would pay for private religious schools to help fund their teachers and textbooks. And so someone sued and said, I don't want my tax dollars going to private religious schools. That's a violation of the Establishment Clause, right? That's government advocating for advancing a religion, being tied together with a religion. We should not be allowed to do that. The Supreme Court said, you're absolutely right. And they established a test, right? 3 criteria to see whether or not that the government is actually advocating for or establishing a religion. So the first thing is the law has to be secular in nature. And so the law in the Lemon case failed it because it specifically targeted religious institutions. It was not a secular law. Second thing is government cannot advance a particular religious agenda. So assisting public school or private religious schools with education, hiring and firing of teachers, textbooks, right? Some of which might include religious materials. It's advancing a religion. Third, government cannot get entangled with any religious institution. So you can't specifically team up with a religious organization to do something. The Lemon case violated all 3 of those. Well, there have been cases like a city that agreed to use public school buses to bus kids to private schools, including religious schools. That was okay because the law was secular, right? We are going to bus all children to school, regardless of where they go. It wasn't advancing a particular religion because kids of all religious institutions and public institutions got to go on the bus. And it weren't getting entangled with religion because they weren't teaming up with any particular religious institution. So that passed the Lemon test as opposed to the Lemon case, which failed. Then we have Engel v. Vitale, which is the case that establishes whether or not, prayer in schools. Okay, so Engel v. Vitale tells us, the Supreme Court tells us that prayer is only allowed in schools if it is student-led within a particular club or group or organization, and not advocated for or advanced or initiated by administration or teachers. So, for example, at a high school football game, principal can't get up and lead everyone in the prayer of Our Father. Can't do that. That's school-initiated, school-sponsored prayer. Can't do that. But a student group that cares about gun violence might be able to have a prayer within their group praying for the people who were killed in recent school shootings. That would be okay. So as long as it's not initiated or led by a teacher or a principal or administrator, it's okay. You also can't have religious figures come to school and lead prayers, right? Because that's school endorsing a particular religious message. You can't do that. So this is the First Amendment. Next video will deal with, among other things, the rights of the accused.